Hello and welcome to the South African Medico Legal Reports Expert Witness Guide training. And we are going to today do the first lesson. We're going to start with Module 1, which is General Principles. Okay, so this particular module forms part of the Expert Witness Guide training. The training is designed to complement the Expert Witness Guide, and we'll look at that in a moment. But it is also designed to guide expert witnesses generally and for CPD points to be acquired. So let's just have a look at the general course overview, just briefly. We have done this in some of the promotional material, but let's just reorientate ourselves. So the course is made up of 5 modules. The first module, which is that which we're starting today, is on general principles. This is your foundation level. Very important to get these general principles right. There are a number of principles. Most of those principles you'll probably have heard of or be aware of, but once you go through them in more detail, you'll get a clearer understanding of those principles. And then the other 4 modules, so on screen, you'll see that what happens is we work from the general to the specific. So we start off with general principles, then specific principles. Those 2 modules are more academic in nature, more sort of, I should rather say theoretical, I suppose, in nature. And then we start looking at the more practical applications, which is the expert report and appearing in court. Those 2 modules dovetail but are quite heavily practical in nature. And then finally, we have a look at the cases and rules of court. It's the key cases. We take a selection of cases, and we take a selection of the rules of court, and then have a look at how all of those 4 modules all actually play out now in actual court cases, and draw on a lot of those principles to understand the key cases and rules of court. And then just on a practical level, each module will run consecutively for 1 week. So there's a week per module. We roll those modules out over a 5-week period. There are a number of lessons per module, and those lessons will obviously be covered during the week that is dedicated to that module. Then lessons will be made available by video and will be on demand. We will make an announcement regarding CPD points shortly. We're just finalizing exactly how that's going to work. 500 Rand per module is the normal price, but for free access subscribers, the training content, in other words, the videos, can be accessed for free depending on if your free trial period is still running. You'll be able to access the training materials. But if you want to do the assessment, you're going to have to unfortunately pay for that. There are administrative costs that go into the assessment, and there will therefore be that charge for the assessment. And the assessments are published at the end of each module, so weekly there will be an assessment done. Then let's just have a look at where we are regarding the general principles, which is module 1. So this is lesson 1, and we're going to deal today with the nature and purpose of expert evidence. And you'll see the other lessons they don't fit exactly. Sometimes we will deal with more than one topic per day, but the other lessons are the relationship between the courts and expert witnesses. It's important to understand that, how the expert works with the courts. And then the next point is establishing the right to give expert evidence. On what basis can expert evidence be received? That's important also for the types of topics that the expert can testify about. Then, very important, developing a logical argument. That is very important, runs all the way through this whole course. That's the golden thread through the whole course, 1.4. Then 1.5, the factual basis for the expert opinion. Must be very aware of the facts and the factual basis on which you are resting your opinion. Can't simply come up with an opinion that is based on uncertain facts. That's one way that you can really get knocked out on your opinion. Then the reliability, relevance, and admissibility of expert evidence. Experts should restrict themselves to matters within their expertise. These are topics that people who are experienced in the field would have come across. And then the prospect of an event occurring should be expressed in probabilities in civil cases. Those are all topics that we will cover during this particular module. let's turn to lesson 1, which is the nature and purpose of expert evidence. The learning objectives and outcomes of this lesson, of this module: a sound understanding of the practical application of the general principles of expert evidence with particular relevance to the function and purpose of expert evidence, the relationship between the courts and expert witnesses. It's very important. In a way, you can look at expert evidence and everything about the admissibility of expert evidence as forming a relationship between the expert and the courts. The importance of a logical argument, as I've already stressed, the factual basis for the expert opinion, a sound understanding of the practical application of the expert evidence, experts restricting themselves to matters within their expertise, and the prospects of an event should be expressed in probabilities. Those are your learning objectives and outcomes. Your prescribed text is the South African Medico-Legal Reports Expert Witness Guide, which you see displayed on screen. It's available in hardcover. Please go to the site. If you are a free trialist, in other words, if you're a member of one of our affiliate organizations, then you will get a 20% deduction off the purchase price of that guide. Very, very good manual, comprehensive, and side by side with these videos will give you a very solid understanding of your role as an expert. I should also mention that the sub-paragraphs are updated as relevant case law comes out. We cross-reference on the website when we comment on latest cases. We do cross-reference to the expert witness guide. Then let's turn to the first topic. So the nature and purpose of expert evidence general. The role of the expert witness in administering justice is becoming increasingly important. Now, those of you that have been doing this for some time will remember that in the 1980s and into the 1990s, the appearance of an expert in a trial was an unusual event, and there was a lot of very careful preparation by the experts and of the experts by the legal teams and challenging cases for judges. These days, that has changed tremendously, and there is the expert evidence in our courts is now commonplace. What sometimes is missing because of that is that level of preparation and attention to the arguments being made by the expert witnesses, by the experts themselves and by the legal representatives. And that is encapsulated by the quotation set out in Twine versus Naidu, that most of the challenges faced by the court arise from the fact that the basic principles about the role, relevance, and value of an expert's testimony are often ignored by the alleged experts themselves and by the parties calling them. This, unfortunately, has resulted in the unnecessary wastage of court time and the unnecessary incurrence of costs by parties. It is for this reason necessary to recall the basic principles involved in the admission of expert evidence. So that, I just want to set the scene really for everything that we do in this course through that quote. It is very important that those fundamental, what the court talks about, the basic principles about the role, relevance, and value of an expert's testimony are fully understood by all experts and by legal practitioners calling experts, cross-examining experts, etc. That is the essence of expert evidence, and those basic principles must be soundly understood. Once the basic principles are properly understood, then that is a good foundation on which to then build the logically reasoned process which goes into every individual case. Then if we have a look at the nature and purpose of expert evidence. So let's have a look at the function of the expert witness. The expert witness guides the court to a correct decision on questions which fall within that expert's specialized field. We'll break that sentence down during the course of these lessons, but it's that question of guidance which is important. You remember that I talked about the relationship between the court and the expert. The expert must regard himself or herself as a guide. That's key. Then to a correct decision on questions which fall within that expert's specialized field. And we will have a look now at some general principles that apply to the expert's specialized field. To that end, the expert witness has a duty to provide the court with abstract or general knowledge concerning his or her discipline, and the criteria necessary to an expert, here's important, enable the court to form its own independent judgment by the application of the criteria to the facts proved in evidence. So it's that link between the facts and the general knowledge of the expert's discipline, which the expert is guiding to the court into being able to assess the facts in the light of the general knowledge. If you want to look at it that way, very helpful. So you have your facts proved in evidence. The expert's role is to assist the court to be able to have sufficient general knowledge relating to the expert's discipline to enable the court to form its own independent judgment. In other words, it's very, very, very important that it's clearly understood that the expert is not prescribing to the court, telling the court what the outcome is within their field. The relationship is different. The expert is guiding the court to its own understanding. That is at the heart of the nature of expert evidence, and it flows from that as to what good expert evidence is. Because a good expert will be able to guide the court through earning the trust of the court, through being able to explain to the court logically and yet simply in terms that the court can understand, so that it can apply its own reasoning process to the facts. That's the role of the expert in a nutshell. And that then should permeate everything you do as an expert witness. Right down to when you get in the witness box, your relationship is with the judge. Now, let's have a look. There are various authorities for the legal representatives. There are various authorities referred to. And then let's have a look at the next paragraph. In essence, the expert witness assists the court in reaching a conclusion on matters on which the court itself does not have the necessary knowledge to decide. So the expert stands in as a trusted advisor. Let's have a look at the nature and purpose of expert evidence, the expert's training, skill, and experience. Now, just building from that previous point about the correct understanding of the relationship between the expert and the judge. It is not the mere opinion of the witness which is decisive. Remember, I said it's not for the expert to prescribe to the court. Here in Glenister, the constitutional point put it this way. It's not the mere opinion of the witness which is decisive. So the fact that you hold the opinion is not decisive. But the expert's ability to satisfy the court that, because of special skill, training, or experience, the expert nature of the opinions expressed by the expert witness may be accepted. Now that goes into the standing of the expert. Are you a person that the court will even listen to in the first place? If you like, step one. And that is where the court will assess whether you have your special skill, training, should be and or experience, I suppose. Whether it should accept your opinions. And then once it decides that it can hear you, then the next phase steps in where you need to explain your process of logical reasoning to the court, and the court will then critically analyze your argument. Okay. So let's look at the nature of expert evidence. The expert witness should put before the court facts that require specialist skill to ascertain them, or to interpret facts that are not readily susceptible to interpretation by a judge, owing to the judge's absence of such specialist skill. Any expert opinion which is expressed on an issue which the court can decide without receiving expert opinion is in principle inadmissible because of its irrelevance. So, there are therefore two requirements for evidence to be classified as expert and for the rules governing expert evidence to operate. One, the evidence must be in the nature of an opinion, and the evidence must be given by a person who is an expert. I'm just going to cover that very last point first. Let's get it out the way. Who is an expert? Remember, the expert is a person who has the relevant training, skill, and or experience. That's your expert. That's your gateway test, if you like. Once that gateway test is passed, then point 2 is covered. You are an expert, and then you've got to convince the court of the cogency of your opinion, or I like to say your argument. It is ultimately, opinion is the correct word, but I think it's very handy to think of it as an argument, because that is correctly what's going on. And then if we look at the nature of the evidence, so once you've got through the gateway of being an expert, then you must put before the court facts that require specialist skill to ascertain them, right? Or we must interpret facts that are not readily susceptible to interpretation by a judge because of the court's lack of specialist skill. And therefore, any expert opinion which is expressed on an issue which the court can decide without receiving expert opinion is in principle inadmissible because of its irrelevance. So you don't need the expert. The court doesn't need the expert because it can make up its own mind. There was an example in a recent case where there was a disfigurement, and there was expert evidence about the severity of the disfigurement, and the judge found that she could observe for herself the severity of the disfigurement, and it was disfigurement to the face. And she therefore applied this principle and said that there was no need for expert evidence on that particular point because she could observe for herself. So let's look at continuing with the nature of expert evidence. The mere fact that an expert witness testifies does not on its own mean that the evidence is expert in nature. An opinion must be expressed for it to qualify as such. Now, the leading case on this principle is AM and another versus MEC for Health Western Cape, where Wallace J.A. drew a distinction between the evidence of a factual nature given by an expert witness and evidence in the nature of an opinion. So let's have a look at the functions of an expert witness. Firstly, experts may themselves have observed relevant facts, and that evidence will be evidence of fact and admissible as such. So that's direct observation by the expert. Expert testifies about that. That's factual evidence. Second, the expert provides the court with abstract or general knowledge concerning their discipline that is necessary to enable the court to understand the issues arising in the litigation. This includes evidence of the current state of knowledge and generally accepted practice in the field in question. Although such evidence can only be given by an expert qualified in the relevant field, it remains at the end of the day essentially evidence of fact on which the court will have to make factual findings. Comes up a lot in medical malpractice cases where there's expert evidence about the generally accepted standard of practice of a practitioner in order to comply with reasonable conduct. Then, third, where experts give evidence concerning their own inferences and opinions on the issues in the case and the grounds for drawing those inferences and expressing those conclusions. So that's where the inferences and opinions sections come in. It's the court regards the providing of factual evidence by experts as different to opinion evidence by experts. So that is also an important distinction to bear in mind. Sometimes as an expert, especially in both categories, but especially that second category, there's a slight blurring of factual and opinion evidence. And then you get certain circumstances where there's a clear inference and opinions of the experts which the expert is testifying about. And then just have a look finally at the nature and purpose of expert evidence. Ultimately, the test for whether the court will allow expert evidence is a relative one, depending on the particular subject and the particular witness with reference to that subject. So it means that where we've got the court assessing and evaluating expert evidence, the court will weigh up various factors, including the subject of the dispute and the particular witness, as to whether the evidence in question is in fact expert evidence. I gave the example of a disfigurement to the face, where there's an assessment that the evidence being given was not admissible because expert evidence wasn't required. But of course, usually the situation is that the court will weigh up the circumstances and will come to a conclusion as to whether it's necessary to have expert evidence on that particular topic or whether that is not necessary. And we will have a look. There are one or two cases in Module 5 that we will have a look at how the court has applied these principles and approached various issues which arose as to whether the evidence was expert in nature or not. And then finally, just to conclude, that sets up the general principles relating to the nature and purpose of expert evidence. In the next lesson, we will have a look at the relationship between the courts and expert witnesses, which will then develop from the general lie of the land insofar as the nature and purpose of expert evidence is concerned. I hope you found that useful and enjoyable, and I will see you in the next video. Thank you.